32 of the House of Commons Standing Committee on Procedure and House Affairs. Pursuant to Standing Order 108, Sub 3, the committee is meeting for the first time on the study of Bill C-25, an act to amend the Canada Elections Act and to enact an act to change the names of certain electoral districts, 2026. We should probably come up with a better acronym than that, but I will leave that to everyone in the room. Today's meeting is taking place in public in a hybrid format, pursuant to the standing orders. If members wish to speak, please raise your hands. I would ask all in-person participants to consult the guidelines written on the cards on the table. These measures are in place to help prevent audio and feedback incidents and to protect the health and safety of all participants, especially our interpreters. A few comments for the benefit of members. All comments should be addressed through the chair. For members in the room, raise your hand if you'd like to speak. And I don't think anyone's on Zoom today. Before we get to our witnesses, there is a draft budget. Is there any opposition to moving that draft budget? Seeing none, the draft budget is approved. I'd like to welcome our first panel, who will also be here for our second panel. Kathy Howara, Assistant Secretary to Cabinet, Machinery of Government and Democratic Institutions, and Rachel Pereira, Director, Democratic Institutions. I understand you'll be making a brief opening statement, and then we'll go to questions from members. Please go ahead.
Je vous remercie, Monsieur le Président, de nous avoir.
Thank you, Chair, for the invitation to appear before this committee today to speak to Bill C-25, the Strong and Free Elections Act.
I'm the Assistant Secretary to the Cabinet responsible for Machinery of Government and Democratic Institutions, and I'm pleased to be here today with Rachel Pereira, who is Director in the Privy Council Office's Democratic Institutions Secretariat. As the Chair mentioned, the Minister will be joining us at 12 this afternoon to speak to Bill C-25, and until then, we are very pleased to answer any questions the members of the committee might have on the bill in advance of the Minister's appearance. Mr. Chair, we're happy to take any questions.
Thank you so much. We'll turn to Mr. Cooper off the bat for 6 minutes, please.
Thank you very much, Mr. Chair. I'm going to ask some questions regarding third-party financing. The bill seeks to close what are significant loopholes that allow for foreign funds to be used by third parties for regulated pre-election and election activities by requiring third parties to set up separate bank accounts for those activities and only use contributions from individual Canadians and permanent residents. However, the bill provides an exception to this requirement, and that exception is that if contributions received by the third party during the previous year is equal to or less than 10% of its revenue for that year, that the third party may use its own funds. So on what basis was this 10% threshold arrived at? Why 10%?
So thank you for the question. And Mr. Chair, I think it's important to start by noting that we do have an extremely rigorous political financing regime in place in Canada, and this is an attempt to ensure that it continues to be as robust as it can be. We took note of the recommendations that were made by the Chief Electoral Officer, which did point to the need for some ability for certain for third parties to be able to use their own funds under limited circumstances. We wanted to prevent, we did not want to prevent third parties from using their own funds.
I understand that, but I wanted to know the 10% figure, how it was arrived at, and I take it from your answer that it was based upon the recommendation of a Chief Electoral Officer.
We did take that into consideration, yes.
Okay, thank you. Now, the exception in the bill bases the 10% threshold on the third party's revenue from the previous year being the calendar year that precedes the calendar year of the pre-election period, or the fiscal year that precedes the pre-election period, whichever the third party chooses. Given that, how would contributions transferred to a third party in any year prior to the previous year be treated. So, for example, if in the year prior to the previous year, the third party received 90% of its revenue from contributions, would those contributions be treated as part of the third party's own funds that could then be used for regulated pre-election and election activities?
Thank you for the question. We can return to you with the details of that, but under the Bill C-25 requirements, third parties will need to identify contributions made by Canadians and permanent residents, knowing once the bill has passed, they'll need to record the name, the address, the date, the amount of when those contributions were received in order to use them for regulated activities.
But that is the case if the exception doesn't apply, and I'm wanting to know whether in the year prior to the previous year, if funds are melded, because if those funds are melded, if the third party can use those monies as part of its own funds, then what would remain is a loophole that would allow for, among other things, foreign funds.
Yes, that is the challenge currently, where there is a transparency gap, as you point out, where third parties can receive funding from other sources, and it will look as though it is part of their general revenue. This measure aims to address that going forward.
Okay, so will you undertake to specifically answer that question? And how
yes,
that would
I
work?
will confirm for monies that were collected previous to the year before the election.
Year.
Yes, understood.
Okay, and you may not have an answer, so if you don't, to the next question, then I'd ask you to undertake the same. But under the exception, if 10% or less of a third party's revenue came from contributions in the previous year, hence the threshold applying, would those contributions be treated as melded and therefore could be used by the third party for regulated activities? So just to be clear, the threshold would apply, but contributions were made in the previous year, but it's the amount of those contributions is 10% or less.
Right, so the threshold for using own funds, and own funds are monies excluding contributions. So those are the revenues generated by the third party. They could use their own funds for regulated activities. So if they meet that threshold of 10% or less received in contributions, they would then be able to calculate the use of their own funds, minus the contributions received.
So they can.
So how would, I mean, funds are sort of, money is fungible. How would that work exactly?
Well, I'll walk through. So for the threshold, so third parties under the bill will only be able to use contributions from Canadians and permanent residents for regulated activities. They will need to report on those, of course. They will be able to use their own funds if those are funds not received from Canadians or permanent residents. For example, selling merchandise, their other business lines, etc. If all those contributions do not exceed 10% of their overall revenues in the previous year, as you've noted. So if I meet that limit, I'm a third party, and I have, let's say, $1,000 in contributions, and the overall funds that I have are $9,000 of my own revenue. The donations at 10% of my overall income, which was the $9,000 and the $1,000, is 10%, and then I would be able to use my own funds because I meet that threshold.
Thank you so much. We'll now go to Mr. Lewis for 6 minutes, please.
Thank you, Chair. I want to thank Ms. Suara and Ms. Pereira for being here and sharing your time and your expertise. Bill C-25, Strong, Free, and Elections Act, reflects a simple but essential principle that democracy must be both open and secure. Canada's electoral system is among the most trusted in the world, but trust is not static. it must be actively protected as threats evolve. And so this bill, I believe, responds directly to recommendations from the Public Inquiry into Foreign Interference, Chief Electoral Officer, Commission of Canada Elections, which we'll be hearing from subsequently. It addresses real and emerging risks: foreign interference, disinformation, deepfakes, dark money, cyber threats, and physical intimidation, without compromising freedom of expression, political participation, or legitimate debate. So we're here in committee to discuss the scope of the bill, that it be targeted and proportional, but at the same time it preserves openness and accessibility to serious candidates, parties, and voters. So if you can share with me, either of you, some of the safeguards that the bill has that would ensure that it captures only intentional, harmful conduct and not possibly a good faith disagreement or error.
Thank you for the question. Thank you, Mr. Chair. I think there are a number of ways, a number of examples in the bill that highlight the kind of balance that we're trying to strike between closing gaps, addressing threats we know are present and need to be responded to, and at the same time trying to strike the right balance and ensuring that honest mistakes are not overly unduly addressed. I think one example is the new provision in relation to false information. We are trying to be very targeted in this measure, ensuring that we are responding to the most critical, a real potential threat that false information about who can vote, how voting is conducted, etc., which could potentially harm the integrity of our system. But the measure is quite targeted, needs to be clear about the kind of intention that the individual has, and it's very clear that they know that they need to know that the information is misleading. At the same time, if we look at some of the measures that we're proposing from an enforcement perspective, we are expanding the number of violations of the Act or offences, contraventions of the Act that can be dealt with as violations of the Act under the administrative monetary penalty regime, providing the Commissioner with greater flexibility to determine whether a violation of the Act that is unintentional can be dealt with through the AMP regime, through administrative investigations, and through tools like compliance agreements, letters of education, etc., so that we can, again, better target the compliance and enforcement activities of the Commissioner. So you find this throughout the Act, where we are trying to strike that balance between closing the gaps and addressing the threats that are real, and at the same time ensuring that we're taking a proportionate, or the Commissioner and the Chief Electoral Officer are taking a proportionate approach to the administration of the Act.
Great, thank you. I think that's what people want to know, that there's a high intent threshold that's set. That seems to be what you're explaining. The Elections Canada, Public Inquiry into Foreign Interference, they all identified gaps. Some of them had to do with election interference and computer system tampering. Are there measures in there that will address some of the issues that were brought up by Elections Canada, Public Inquiry into Foreign Interference?
Yes, Mr. Chair. The most urgent recommendations from the Public Inquiry on Foreign Interference have been either wholly or in part addressed, and same with regards to the recommendations made by the Chief Electoral Officer and the Commissioner for Canada Elections in their 2022 report. So, for example, the example that was given with respect to unauthorized use of a computer, we are expanding that particular protection so that it's not just about attempting unauthorized use of a computer to attempt to influence the results of an election, but actually also for attempts to disrupt the conduct of the election. So that's an example with respect to that. A number of recommendations were also made that some of these protections which are in place today only apply during the conduct of an election, and the recommendations was that they should apply at all times. And so the bill expands expands a number of the key safeguards so that they apply not just during the conduct of an election, but at all times, including, for example, a ban on foreign influence of voters. And there is also application of these protections to actions that take place outside of Canada as well. So these were among the critical, I would say, recommendations that were made, and that were the basis of the measures that you see in the bill today.
Thank you for taking those recommendations and helping us shape this legislation. Appreciate it. That's my time, Chair.
Thank you so much. With 5 seconds left to spare. Madame Normand, 6 minutes, please.
Merci beaucoup. Merci pour votre.
Thank you very much. Thank you for being with us. I have questions regarding Section 9 of the bill on reports. Can you summarize the amendments proposed by C25? What was done before regarding reports 5 days before an event and the days after an event, and what is being modified through C25 regarding producing the details of an event, participants, and guests, for example? Thank you for the question.
Regarding changes to the regulated fundraising event regime, currently the regime requires advance notice 5 days before the event with some of the details of the event, including the location and the venue of the event. That 5-day advance notice will be removed, it will be repealed. The rest of the regulated fundraising event regime is in place. That means that 30 days after the event, there's a report that will be issued with all of the details that were included before. So the name of all of the attendees, 18 and over, the venue, the prominent attendees, the amount that was contributed to attend. All of those details will be in that report. The only difference is that the location will be limited to municipality and province, so that the level of detail of the venue will change.
Et donc pour le rapport
So for the information that needs to be produced 5 days before, there is no longer any information being produced. So it's not limited to the municipality even. We're just not indicating that an activity is being organized. Is that correct?
Correct. There's no requirement under the law for parties to provide an advance notice. They could if they wish to, but it's not required.
Merci beaucoup. Ma deuxième question.
Thank you. My next question has to do with Section 5 of the bill. I understand that there are amendments to the preliminary lists that can be obtained by parties, and if I understand this correctly, in order to have access to these lists, a party needs to have presented candidates in at least in 2/3 of ridings. Can you tell us about the impact that can have on the bloc who only has candidates in Quebec?
I can take it. Je vous remercie pour la question.
Thank you for the question. There are 3 criteria established in the legislation, so that's not the only one that needs to be met. And perhaps to clarify, what we're trying to do is to protect the integrity of information that can be found in this list. It is currently accessible to admissible parties who haven't identified candidates who will be presented in different ridings. So the candidate needs to be identified, a candidate who is endorsed. So it needs to be in at least the last 2 elections, or having a candidate in 2/3 of ridings, and then they would have access to that list. following an analysis, all current parties in the House would continue to have access to that list. Thank you. So they're not cumulative criteria. Indeed. Thank you. My next question has to do with protecting data. For example, the situation that happened in Alberta a few days ago. There were parties that had access to lists, and they can give them to other people willingly or unwillingly. And was that taken into account when creating this bill? Are there any measures, any additional measures that were taken? And if not, should that be part of potential amendments that we can propose? You only have 1 minute, but we can come back in the second round of questions. What happened in Alberta is still being investigated, so I can't speak to that necessarily. But what I can say to the committee is that with the given legislation, there are strict guidelines regarding who can receive the list and how it can be used. Only registered and admissible parties and candidates and parliamentarians can receive the list, and it can only be used to communicate with voters. If anyone consciously uses personal information from a voter's list for any other reasons, they are violating the law, and there can be a fine of up to $10,000 and or a prison sentence of a year. The commissioner can investigate any potential infringements to the legislation, and she can do so following the public's complaint, or she can initiate her own investigation. There are measures in the bill, but they don't speak to that element specifically. They do still strengthen the importance of protecting personal information.
We'll now go back to Mr. Cooper for 5 minutes, please.
Okay. Thank you very much, Ms. Pereira. Just following up on your hypothetical, in the case of the 10% exception, whereby if 10% or less of a third party's revenue came from contributions in the year prior to the pre-writ election year, as I understood you to say, if during that period the third party received $1,000 in contributions and $9,000 in general revenue, the amount of money that they could spend for regulated activities would be $9,000. Do I have that right?
No, thank you for the question. They would be able to use their $1,000 in contributions, but because they meet that threshold, they could additionally use some of their own revenue. So if they have $9,000, presumably they wouldn't use all of their revenue, but they could have access additionally to using those funds for regulated activities, in which case they would then need to provide financial statements to Elections Canada as part of the reporting requirements to demonstrate the source of funds.
So they could use those contributions. Those contributions would be treated as their own funds.
Contributions would be contributions from Canadians and permanent residents, and those would have the name, address, and so on and so forth that are required for the reporting.
Okay.
So those are contributions from Canadians as required. But should some subset of third parties have their own funds, and for example, unions mostly use their own funds as membership dues are their own funds and may not receive a lot of contributions. So they would use their own funds, not from contributions.
Okay. Now, take another hypothetical. Suppose that a foreign source decided in the previous year to buy a whole lot of, I don't know, overpriced merchandise from the entity, from the third party, thereby inflating the revenue of the third party, what provisions in the Act, if any, would counter that effort to work around the intent of the Act, which is to stop the use of foreign money from influencing our elections via third parties?
First, that third party, if they were to participate or they wish to participate in the election and participate in regulated activities, they would first have to use contributions from Canadians and permanent residents.
But not necessarily, because I'm citing an example where a foreign entity was purchasing merchandise, goods, items for the intent of circumventing the Act. And I know there are certain provisions where if there's evidence that it was willfully circumvented, but these things are very difficult to establish, very difficult to prosecute. So it seems to me, but I'm open to hearing you, that this is another way to get around the intent, which is to stop the flow of foreign money into third parties.
No, thank you. Thank you for that point. Third parties are not necessarily exclusively political actors, so they operate all the time.
I understand.
Yeah.
Sorry, and I understand that third parties can be any number of entities with any number of objectives, but the issue at hand is that foreign money, foreign sources ought not to be influencing our elections, including through third parties. There are loopholes that allow that to happen. This bill goes a long way, I believe, to trying to close those loopholes. But it seems that this 10% exception keeps loopholes in place or opens the door to new loopholes. That's what I want to get to the bottom of.
Yes,
Very brief answer.
Understood. Third parties can sell, their products wherever they wish to. So it could be legitimate sales and sources, and so they do have revenue streams for that. But when it comes to regulated activities, they would not be permitted to use those funds. They would need to provide some financial statements to demonstrate where that money comes from. It's not necessarily nefarious if a foreign entity were to purchase something that the third party actually produces. It may be a genuine, legitimate transaction, but there could be a bit of a challenge if it's their general revenue, but it is for regulated activities. They would need to report on that, provide their financial statements in terms of demonstrating the source. It could be seen if there's 90% of the purchases is coming from some other country, that may raise a question or a flag on the part of Elections Canada.
I'll have to cut in. We'll turn to Ms. Fancy for 5 minutes, please.
Thank you very much. And through you, Chair, I'd like to comment that for once I think I'm agreeing with my colleague from across the way there, Mr. Cooper, in terms of his line of reasoning. For today, though, I'd like to talk a little bit about mis and disinformation and how we can help some of our vulnerable populations of people in our country. So I'm a former educator, and I really worry about young girls that I've taught, about my own daughter growing up in an environment where what she sees online might not be trustworthy. So having seen firsthand some of the mis and disinformation throughout the election, and this was my first election, I'm increasingly concerned about how quickly these technologies are evolving. So this bill does a really good job in addressing the AI-generated impersonation and deep fakes. So in areas with limited access to local media, where I'm from in Nova Scotia, it's quite rural, where residents might rely more heavily on social media, I'm asking if you feel that these provisions will be sufficient enough to protect voters from increasingly sophisticated digital misinformation. Thank you.
Thank you for the question. I think there are a number of measures in this package that will address the concerns that have been raised, and perhaps I'll just start by reminding the committee that we are also thinking about Canada's plan to protect democracy when we are thinking about this particular piece of legislation. And of course, one of the pillars of that plan is a more informed and prepared citizenry. So I think that is important. We are indeed, the bill proposes to expand the current prohibitions against impersonation in recognition to include impersonations through AI and deepfakes. So we recognize that this is a threat, and it's a growing threat. And so this is something that the bill will make extremely clear, that those kinds of impersonations are unauthorized. I think the measure that I referred to earlier around false information is also relevant in this context. It is certainly meant to address an emerging threat and a real potential harm to the integrity of the electoral system, and so this will address situations where an individual intends to affect the outcome of the election, the results of the election, and the conduct of the election itself. If they know that the statement they are making is false or misleading, and it is a statement about the core elements of the electoral system: who can vote, how they can vote, how to register to vote, process for counting votes, and ultimately the eventual results of the election. So these are enhanced protections for our electoral system that the Commissioner for Canada Elections will be able to administer.
Thank you very much for the answer to that question. I do believe that this bill does seek to strengthen confidence in the electoral system. That as well, in talking with some of my residents in my riding, they talked about changes to riding names and some of the concerns that they might have there. So changes to riding names have raised concern, including with seniors, some of the different heritage partners within my riding, and Indigenous communities. And I'm wondering, how important that is to the electoral district names, and how that reflects kind of local history or local identity, and should there be some stronger safeguards or consultation requirements to ensure that those perspectives are properly considered?
Thank you for the question. So the names of riding or of electoral districts are determined by the independent electoral commissions at each decennial exercise. During that process, members can propose names and put forward objections, but ultimately those decisions are made by the independent commissions. However, members of Parliament can, between those decennial exercises, propose name changes to the ridings for Parliament's approval. So in previous decennial exercises, that has been the case, whether through government bills or private members' bills. In 2014 and before that in 2004, there have been bills that have changed the names of ridings. That is within the purview of members of Parliament to propose and for Parliament to approve.
Thank you so much. We will now turn to Madame Normandin. 2.5 minutes, please.
Merci beaucoup. J'aimerais...
Thank you. I would like to come back to the question that I asked earlier regarding using personal data. What we learned from Alberta is that there are situations where women who were victims of violence had to move in order to protect their address and the confidentiality of that. Are there any measures in the bill if someone can request to be excluded from electoral lists? For example, someone who has a violent partner, could they make a request so that their name not be sent to candidates who would have legitimate access to these lists to avoid this falling into the wrong hands?
Thank you for the question. I believe, so not through this bill, but there is a existing requirement in the Canada Elections Act. Should an elector wish to be removed from a list, that they can, in writing, request that of the Chief Electoral Officer for a period of time. And they will still receive the voter information card. It doesn't prevent them from voting, but they can make that request.
Merci beaucoup. Et sur un autre aspect.
Thank you. And on something different now, the minister, during question period at the House and during second reading, said that he was open to reviewing the public contribution to political parties. Do you have at your disposal the annual amounts given in tax credits to individuals who make donations? Do you have this information by political party? Is this information that is available?
Je ne suis pas certaine.
I'm not sure. I can come back to the committee with that information, but I suspect that it is not available in that way, but we'll verify that. If it does exist, if you can share those lists with us, that would be great. Thank you.
To Mr. Jackson for 5 minutes, please.
Thank you, Chair, and thank you to both witnesses. Appreciate you being here today. I have a bit of a different hypothetical question than Mr. Cooper. So if I was a foreign entity and I purchased $1 million worth of consulting services from a third party in Canada, how does this act ensure that that money is not used towards influencing a Canadian election?
So there are requirements for third parties. They need to register if they wish to spend $500 or more in the election, and then they're subject to a variety of reporting requirements. I'm just looking for the maximum thresholds. If you give me a moment.
Sure.
So there are also pre-election and election period, as you know, spending limits for third parties. So what this bill does, I'll repeat again, is that for those third parties that wish to participate and register under the Act as a registered political party, they can, during the election period, use funds from Canadians and permanent residents. If those funds are 10% or less of their overall revenues, they will be able to use those own revenues with reporting requirements that would provide transparency to Elections Canada to know what the source of those funds were. So a very large third party that generates a lot of business that would be part of their financial statements, and that might raise some questions from Elections Canada in terms of where those funds are coming from. They could be legitimate sources of funding. I don't know if that answers your question.
Well, sort of. I guess what I'm curious is I'm sure the consulting services in my hypothetical scenario would be legitimate, but if they're being purchased before the pre-writ period, before the year required, it's part of, like, if we're in a 4-year election cycle, if an election is year 4, if they're purchased in year 2 of that cycle, do they fall under the 10% cap as it's set out in this bill?
I mean, third parties can participate outside of election periods, and wouldn't be regulated. So it's regulated during the election, pre-election,
so
election
it would
period.
not fall under the provision then of the Act currently if it was in
that
year
money
2.
came in the year before. So if it's the fiscal or the calendar year that they use, that would be part of the calculation. So the year before the election, if that money was coming in, it was part of their revenue stream.
Right.
That would be captured as part of that threshold.
But not 2 years before an election.
I will return to this committee with a confirmation of that response to your question.
Okay,
as
I would
before.
appreciate
Yes.
that very much, because I think these
Yes.
entities or foreign actors are planning well in advance. They know, especially now that we're in a majority, when the election theoretically would be, and so planning out a time frame is not hard for them to do if they're going to make a contribution to try to influence a Canadian election. How much time, Chair?
About 1:10.
Okay. Just in terms of the reporting requirements for entities, I'm curious about, you commented on if these books or contributions are coming through, their books of a third party would have to be, it would have to be categorized separately. Is that a new requirement, or is that something, and what does that look like in terms of the accounting practices for third parties and the change that it will require for them if this bill becomes law?
Right. So they, thank you for the question. They will need to demonstrate that the revenues are their own. Not all third parties might have the same infrastructure and the type of accounting and financial statements that other third parties might. So there's a bit of flexibility in terms of it's a statement in line with common accounting principles in the Act. So they would need to provide that to demonstrate the source of those funds. Yes, it is a new requirement because the threshold is a new requirement. I would just add in terms of why the requirement is here, or why the 10% threshold. As it was noted earlier, the Chief Electoral Officer had proposed acknowledged a couple of approaches in his 2022 recommendations report to get at the transparency gap that we're talking about. One of them was to have a more restrictive regime where third parties could only use Canadian contributions from Canadians and permanent residents. But he had noted the potentially significant charter risks with that, given that third parties also generate legitimate funds in Canada, Canadian funds, and so it would have raised some charter questions, which is why he had proposed the approach that is reflected in the bill.
Thank you so much. Madame Kayabaga, 5 minutes, please.
Thank you, Chair. Apologies for my voice today. I want to welcome the officials in committee today and thank you for the work that you've done on this bill. I think this has been a bill that has had a lot of consultation, and you did provide an opportunity for all members to be able to ask questions and technical briefings, so I really appreciated that. I did want to ask some questions around some of the gaps that are currently in our Elections Act that you think Bill C-25 is going to close, and what risk you view that would remain if we didn't act, as well as, based on your experience, have the recent incidents, including the Alberta case, exposed vulnerabilities for our act and how elector information is accessed or shared?
I think, so thank you for the question. One of the gaps we and others had noted was the fact that most of the protections, which are very strong protections for our electoral system, were really only in place for the duration of an election. And so this is one of the recommendations that was made in the context of the public inquiry on foreign interference, that that kind of a protection against, for example, foreign influence of voters or misleading publications, etc., that those really needed to be in place at all times. And so this is one of the gaps that we're closing with the measures that are in this bill. We know that, as was mentioned, threats to our electoral system don't just happen during the electoral period. So this, I think, is quite important. One, in terms of the privacy of information, and in particular voter lists, we did take note of the Chief Electoral Officer's recommendation that there was a vulnerability with respect to the preliminary list of electors, and so the bill targets a measure there as well, which we've already discussed, with respect to ensuring that those lists, that list in particular, particular does not fall into the hands of an entity that does not actually intend to endorse a candidate, but is looking for access to personal information. So those are some of the examples of the gaps that the bill proposes to close.
I have a question around the enforcement of that the bill provides. And in practical terms, how would enforcement work when a violation occurs? For example, I do want to also touch the scenario where the new administrative monetary penalties would change behavior compared to the how does that change the behavior compared to current regime? If we kept status quo, would that look like versus the new step that we're taking?
I think there are a number of important measures that are included in the bill to strengthen enforcement of compliance on the part of the Commissioner of Canada Elections, and this is also a response to the recommendations that she herself has made in 2022. A couple of examples I can point to. At the moment, if she is conducting an administrative investigation, she cannot compel an individual to cooperate with her investigators by attending an interview, providing information, producing documents. If they don't cooperate, she must go to court, which of course is more onerous and is an inefficient way of dealing as swiftly as possible with enforcements of the Act. And so we are proposing new authorities for the Commissioner that are very much in line with authorities that are available to similarly placed Commissioners. With respect to the administrative monetary penalty, we are proposing to increase them. At the moment, the maximum penalty for individuals is $1,000, and that would go up to $5,000. And for entities, did I get that wrong? $25,000, my apologies. So $1,000 to $25,000. And for entities, the current maximum is $5,000, and it would go up to $100,000. And of course, the objective there is a deterrent effect, and would be more in line with some of the regimes that we find in other provinces.
Thank you so much. What we'll do next, we'll go through another round short. We'll do 3 minutes Conservative, 3 minutes Liberal, 2 minutes Bloc. We'll then suspend for a few minutes for the Minister, and so we can have the full hour. Mr. Jackson, go ahead. 3 minutes, please.
Thank you, Chair. And thanks again to the witnesses. Appreciate you undertaking a couple of those questions and getting back to us just for clarification on how that applies to a 4-year election cycle. I think that's important for committee members to understand as we're considering this bill. As Mr. Cooper said, we're generally supportive of a number of the provisions that came forward in this piece of legislation. Just looking for clarity on a couple of those items. I'm just wanting to follow up specifically a little bit on the monetary penalties as well. I'm wondering, and I apologize if I missed this already, but where you arrived at the $100,000 new proposed monetary penalty for entities in the bill.
Thank you for the question. So we've looked at a couple of different examples, one being provincial and territorial comparable election laws. And we also looked at other federal pieces of legislation where there are administrative monetary penalty regimes in place, knowing that the CEO and the CCE have noted that the current maximum amounts of $1,500 and $5,000 for individuals and entities is very low and does not help compliance or serve as an effective deterrent. And so I can give some examples of how this aligns. The new maximums align with other provinces.
Sure. Maybe if you could just provide those to the committee after the fact. You probably don't have to read them into the record, but I would appreciate that.
Sure.
You mentioned earlier in your testimony that the Chief Electoral Officer had provided feedback that going to as allowance of 0 foreign contributions would potentially, I think you said, chief electoral officer thought that might result in a charter challenge. And I'm just curious for a little context around that. That surprises me that somehow the charter may come into effect with relation to foreign contributions, or did I understand that wrong? Please clarify. Thank you.
Yes, thank you. No, I may have articulated it not clearly, but just to be clear, the option to limit third parties in Canada to participate in, to not use their own funds at all in regulated activities. So legitimate Canadian companies generated funds in Canada could be seen as limiting freedom of expression. And so that may be too restrictive. That was the consideration around that approach. Certainly, a more restrictive regime would limit circumventing other funds from coming into the system. In other words, limiting only to Canadian contributions, Canadian citizens and permanent residents would be quite restrictive. So the consideration was around limiting Canadian third-party legitimate funds.
Thank you so much. We'll now go to Ms. Vandenbeld, please, for 3 minutes.
Thank you very much, Mr. Chair. Thank you to the officials for being here and answering our questions. I'd like to pick up on actually the question that Mr. Jackson was asking about the administrative monetary penalties. I'm back on this committee after a 9-year gap, and a decade ago, the Chief Electoral Officer was at this committee asking for additional monetary penalties. But in addition to what you just outlined, the reason was that there's a really big gap between a criminal threshold and $5,000. And so there were a number of things that otherwise, if it was a penalty, might have been pursued, but it didn't really warrant going the criminal route. So is this also a way that we can address those issues where it wouldn't probably be something that would go before the courts, but it was bad enough that should warrant a high fine?
I think that's right. And in fact, what we're also doing is expanding the number of contraventions of the Act that can be dealt with through the administrative monetary penalty regime to give the Commissioner greater flexibility to deal with things that need to be dealt with, but not through the criminal process.
And also, I noticed that in the bill in C25, it talks about cryptocurrency, gift cards, making sure that these can't be used. I would have assumed that that was already the case. I know that we have such a strict regime that it, I think, comes as a surprise to most of us that cryptocurrency donations and such would even have been allowed. So is this something new, or is this, yeah? Okay.
It is new.
Okay.
So we will be introducing that prohibition, or Parliament would be introducing that prohibition in the Canada Elections Act for the first time. And it is meant to respond to the fact that these are difficult to trace and can be a conduit for foreign or dark money coming into the system. So a robust system will become even more robust.
Sounds like some very important changes. Thank you.
Madame Normandin, 2 minutes, s'il vous plaît.
Merci beaucoup.
Thank you very much. A lot of the new amendments have to do with candidates for party leadership. And we're adding potential candidates as well. Parties have different processes for nominations. It might be more difficult to know what defines a candidate. And can you describe how we'll define a potential candidate for different offenses? It seems to be quite subjective. Have you thought about how we are going to identify a potential candidate in order to better frame potential offenses?
Yeah, thank you. Thank you for the question. Potential candidate is already defined in the Act. I'm sorry, I don't have it in front of me, but the changes you're referring to, where there are new protections for nomination and leadership contestants or contests, or certain measures are not being limited to the election period, so the limitation on during the election period would be removed. Consequently, that would include, potential candidates eligible parties, so the actors that operate also outside of an election that would be captured. So those sort of consequential amendments to those provisions to ensure that all of the actors that operate not just during an election would be captured, so they are prohibited at all times.
Thank you so much. We'll suspend for 5 minutes and come back with the minister, who I see in the back of the room.